To accept your submission, we'll have to postulate that clause 3 becomes a sort of a constitutional article which falls into desuetude after 7 years.
Yes, absolutely.
How can that be?
Well, as I-
Clause 3 still continues to survive.
Well, as
The limitation
Kindly
on
see
clause 3 may cease to operate.
kindly see 369.
See, 371 begins with a non-obstante clause. It
Yeah.
overrides the entirety of the Constitution.
Absolutely.
But
So does
clause 3 contains a non-obstante clause which overrides clause 1 as well.
Yes.
So therefore, notwithstanding, because 371 makes special provisions in relation to the state of Jammu and Kashmir.
Correct.
But 373 has a non-obstante provision which overrides the non-obstante clause in clause 1.
For that period, Manoj, we are not disputing that. What your lordships is putting to me, there is a structure in place that was envisaged by the constitution in Manoj 1950. At that time, there was no constituent assembly. Why did they mention constituent assembly? Need not have mentioned it. Kindly look at it from that point of view. What was the reason to mention constituent assembly in 370 when it was not even in place? They could have said government of Jammu and Kashmir. Why did the constitution makers, Manoj, include the term constituent assembly in 3? Because they knew that the constituent assembly will frame a constitution.
There was no limited, the acceptance of sovereignty of the Dominion of India was complete. They didn't say in the instrument of accession that we accept the sovereignty of the Union of India for some limited purposes. They accepted the sovereignty for all intents and purposes. That acceptance of sovereignty was complete, but they reserved certain rights to themselves over certain legislative subjects. So in that sense, the accession was complete. The acceptance of sovereignty was complete. Now, consistent with that, therefore, it said that in clause 3, that the Union of India would have, the President of India would have the right to abrogate Article 370. It conditioned that subject to
not the Union of India, but on the recommendation of the Constituent Assembly. Not Union of India has no right to till that is recommended. The word is recommendation of the Constituent Assembly. Then they can exercise that right. That's how you interpret a proviso. You can't say that they have the right sovereign, forget the proviso, even the recommendation of the Constituent Assembly, because it doesn't exist. Then 368 2 proviso also goes, Maras. Therefore, the reason is simple, Maras. The genesis of it was the fact that in 370 itself, it was mentioned that the Constituent Assembly has a role to play in the abrogation of 370. Otherwise, if your lordship says it had no role to play, there was no need for 370 sub-article 3. And look at the concurrence power. Even those powers were of no relevance thereafter because the constitution of Jammu and Kashmir was in place. Therefore, there was no need for concurrence anymore. Because now you have a constitution of the Jammu and Kashmir. So that also became ocious. You have to see, Malad, the historical perspective in the context of which Jammu and Kashmir ultimately signed the instrument of accession. Nobody disputes whether they are integrated into India, but subjected to a constitutional provision.
Therefore, the submission is that once the period stipulated in the proviso to clause 3 had come to an end,
yes,
the power under clause 3 itself came to an end.
Because it's no longer alive. The Constituent Assembly, like in India, Malaj, can, for example, today, Malaj, there can't be a provision in the Constitution of India with reference to a Constituent Assembly, because the Constituent Assembly has worked itself out. It has formed the Constitution. Now, if it is decided that they would abrogate 370, the Constituent Assembly would have said, we abrogate 370. Which is why it was a temporary provision. Not because of the fact that under as a Union of India, it was deemed to be a temporary. How could it be?
Sorry, interrupting you at this stage. It does maybe just putting a question.
Sure.
I'm not. If one looks at Article 370, clause 1B.
1B, yes.
The power of the Parliament to make laws for the state shall be limited to it says matter in the union list and the concurrent list in consultation with which in consultation with the government of the states are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the Dominion of India.
Right.
To such other matters in the list as with the concurrence of the state, government of the state, the president may, in the order may specify.
Yes.
Then explanation deals with what is meant by the concurrence of the state.
Right.
Then it says that provided that no such order, the first proviso, provided that no such order which relates to the matter specified in the instrument of accession of the state referred to in paragraph 1 of subclause B shall be issued except in consultation with the government of the state.
Correct.
Provided further that no such order which relates to matters other than those specified in the last preceding proviso shall be issued except with the concurrence of the government.
That's right.
So the second proviso talks about concurrence of the government.
Yes.
Now, if one looks at clause 2,
Yes.
it deals with a situation where the assembly or the government of the state is not there. It deals with the period when the constitutional assembly of the state was in existence, but the government or the elected assembly was not in existence. And therefore, the proviso to clause 3 will only be applicable as long as the government of the state or the assembly is not elected. Because election of the assembly will take place after the constitutional assembly of the constitutional assembly of the state of Jammu and Kashmir enacts the constitution.
Government was always in place from day one.
No, maybe so.
Government is always
Because
in place from day one.
that appears to be the broad outline of this, outline of Article 370. What clause 2, when it refers to the constitutional assembly of the state, it is for the purpose of for framing the constitution of the state, which shall be placed before the assembly for such decision as may be taken thereon.
Correct.
So the constitutional assembly of the state makes the constitution, frames the constitution, it goes before the constitution.
No, it can state in the constitution that the 370 is abrogated. What problems are there? It has the power. That's why there is a constituent assembly. And it says, notwithstanding anything in the foregoing provisions, kindly note that. Notwithstanding 37(1)(b)(1) and 37(2), notwithstanding any of that. So, you start the article by saying notwithstanding anything in this constitution, and 3 starts with notwithstanding anything in the foregoing provisions. That is notwithstanding the opening part of the article also. There was a government. Yes.
Extent of Constituent Assembly of the state.
Yes.
If sub-article 3,
Yes.
according to you,
Yes.
has become non-existent, ceased to operative,
Yes.
then how the very temporary nature of Article 370 will survive?
That's why, because it's temporary, because the Constituent Assembly had not been framed, but at that point in time had not been constituted in 1950 when this provision was added in the Constitution.
No, if sub-article 3 goes, then that means Article 370 can never be abrogated.
Yes, that's the whole point, Mullah. That is our case.
Then how it is temporary?
It is temporary because when this article was framed, Mullah, there was no Constituent Assembly. It was the Constituent Assembly which could have taken the decision that we will abrogate 370 and merge completely with the Union of India like any other state.